Hi, it's Shavena here. And in this video, we're back with Anisha, who is a barrister, to further explore court proceedings around child sexual abuse cases. And in this video, we'll be focusing in on what measures, special measures, as they're referred to, are in place during the court proceedings, to kind of protect survivors who are undergoing the process. So, Anisha, should we start with just a broad kind of outline of how survivors are protected in the system? Most people may be concerned about the trial, having to face the perpetrator, retelling, and essentially reliving the incident to complete strangers.
Yeah,
So
I
yeah.
mean, there are a multitude of different measures in place to protect complainants, to allow them to give their best evidence and not feel intimidated by the court process. Often, complainants in sexual offense matters will be classed as vulnerable witnesses, but there is a spectrum in that those who have disabilities or are in their youth makes them particularly vulnerable. So they'll be offered something called a Section 28 cross-examination. So you see how we first, in our first video, we mentioned video recorded interviews, which substitute evidence in chief. Well, under Section 28, one can have their cross-examination also pre-recorded. So that saves the complainant from having to attend court for trial and saves them from having to speak directly to a jury at all. And on top of that, an extra measure in place is that the cross-examination questions in a Section 28 are reviewed by the judge and the prosecutor prior to the questioning. That ensures that the questions are relevant, they're concise, and they don't actually trip people up as such.
So, what can someone who doesn't fall into that particular category expect in terms of protection?
For those who don't fall into that particular category, there are plenty of other measures in place. So these measures can actually involve giving their evidence from behind a screen. So these screens can take various forms, such as a curtain or a board that essentially wraps around you and it prevents you from seeing the defendant or the defendant seeing you. In fact, the only people the complainant can see are the judge, the jury, the prosecutor, and the defense barrister. Another option might be something called a live link. So a live link allows the complainant to appear on a TV screen in the courtroom, but they're giving their evidence in an entirely different room in the court building or from a police station. And this gives the complainant some comfort for not being, in the presence of the defendant. So those are the two most common special measures offered. There are other things they might be offered to make the court process easier. For example, complainants can request or witnesses can request to see the courtroom in advance, to meet the barristers in advance, to meet the judge beforehand. Witnesses can ask for witness care to be on standby and support them whilst they're giving evidence. There's basics such as being seated whilst giving evidence or being able to drink water in between answering questions or just asking for breaks in between giving evidence also.
What's the cross-examination process like for survivors? I think there's always a concern that it might be quite intrusive.
I mean, at the end of the day, defense, they need to challenge the complainant's account based on what their client, the defendant, says happens. Has happened. So all the questioning has to be in line with the defendant's account and the innate flaws or the inconsistencies in the complainant's account. There is legislation in place surrounding questioning complainants on their sexual history. This is a protection. So if defense would like to question the complainant on this, then they have to apply to the court. They have to seek leave from the court. It's a whole process. So to ever be able to bring up a complainant's sexual history, it just has to be highly relevant to the case. So an example of where that might come into play is where the trial issue is whether the complainant consented or not, and the defendant saying, well, they did consent. The defendant might then want to bring out previous occasions where they believe the complainant has consented. So that might be a Section 41 applications. That's what we're talking about, previous sexual history of the complainant. Of course, that's far less relevant for child sex cases where consent just never comes into play. But that is a protection afforded to those in these types of proceedings. But throughout the trial, the judge will be present, they'll be watching, they'll be listening, and they'll be there ensuring that questioning isn't too aggressive, or if a point has been repeated and labored enough, then they'll raise it with defense. Um, Genuinely, the court goes out of their way to make court proceedings as seamless as possible for the complainant.
I think a lot of survivors might worry that they won't be believed by a jury, or especially with historic cases, there's difficulties because of the delay in reporting, which might cause speculation. How might all this be dealt with?
So the court is very accustomed to dealing with these types of offences. A judge is there to provide guidance and directions to the jury. So on the outset or in their summing up at the end, the judge will direct and caution the jury to cast aside any dangerous assumptions, such as what a stereotypical victim of a sex offence might look like, or a stereotypical perpetrator might look like, or how you might expect a person should have reacted in that situation, or how someone, even when giving evidence, how they should be appearing. They'll be directed to cast aside any of these prejudgments. But particularly in terms of historic cases, the judge will again direct the jury that different people react to situations differently. And that applies even more so to children who can be confused about what's happening to them, especially when it's maybe happening in their own home. Children might, whilst feel that something's wrong, they might be confused about it or might not know how to articulate it. That's the sort of guidance that is elaborated on by a judge to the jury. So the court system is aimed to be as fair as possible.
Thanks, Anisha, for talking us through these special measures that are in place to protect survivors. Um, if you do have any questions, please do get in touch with us at supportandwellbeing@anbu.org.uk. And or if you would like support in terms of discussing your options and or finding out what services are available to support you if you are a survivor, not a survivor of childhood sexual abuse, please do fill out our self-referral form on the ISVA page of our website, also in our bio. Thank you.